Good evening, America. This is Jeff Desk. This morning, right at 10:30 Eastern, the United States Supreme Court issued a brief yet decisive order. The justices turned down a request tied to a significant legal matter. Every single one of the 9 justices stood together. No dissents, no separate statements. The complete decision consisted of just 2 words: application denied. That simple phrase brought an end to months of courtroom battles. This decision arrived precisely 72 hours following the moment Melania Trump's attorneys delivered a formal proposal to federal prosecutors. In it, she detailed the information she would provide in return for potential protection against any charges. These 2 major developments occurred within 3 days of each other, and the close timing points to a clear link between them. Before anyone brushes this off as rumor or overhyped reporting, everything here draws directly from official court documents, formal agreements, and Supreme Court directives. These materials sit in the public domain. No hidden sources, no unnamed insiders. You can easily access and confirm them yourself. What has now been firmly established in the eyes of the law is this: if you're following this ongoing matter and value clear, in-depth legal breakdowns like the one you're hearing, please take a second to subscribe and enable notifications. You won't want to miss the next developments. Melania Trump has chosen to relinquish her marital communications privilege. This is the rule that generally prevents one spouse from being compelled to give evidence against the other in court. She made this choice freely and deliberately. The material she has agreed to share breaks down into 3 primary categories. First, financial records that appear to reveal knowledge of inaccurate asset appraisals. Second, various exchanges, such as conversations regarding property worth and loan-related materials. Third, her personal account as a witness, which would reinforce statements already provided under oath by accountants and financial officers to the grand jury. With the Supreme Court having dismissed the last possible challenge, every avenue to halt or postpone this has closed. No further appeals remain, no additional delays can be requested, and no more technical maneuvers are left. The grand jury now stands ready to receive her account in the very near future. Adding to the pressure, her former spouse's hearing for a cabinet position is scheduled for the beginning of March, roughly 6 weeks from now. Let me walk you through the precise sequence of those 72 hours, because the timing was anything but coincidental. On Monday afternoon, around 2 p.m. Eastern, Melania Trump's counsel forwarded a document to the special counsel team. This filing is known as a proffer letter. Put plainly, a proffer acts as an advance outline. The individual describes their knowledge, what they intend to state under oath, and the supporting materials they can supply. In exchange, authorities evaluate whether to grant immunity, shielding the person from prosecution tied to that information. This procedure occurs frequently in federal investigations. What sets this instance apart is the identity of the individual involved and the substance of what is being offered. Then, on Tuesday afternoon at 2 p.m. Eastern, exactly 24 hours later, the legal representatives for the accused submitted an urgent petition to the Supreme Court. Things escalated quickly here. What are your initial thoughts on all this? Share them honestly in the comments below. Could this mark a decisive shift? I'll respond to as many as possible. Let's discuss it. Their request sought to prevent her from appearing before the grand jury. The core claim centered on the idea that a spouse providing testimony would infringe on constitutional safeguards for marital confidentiality under the Fifth Amendment. Preparing and lodging an emergency petition within a single day is remarkably swift. Typically, such filings require weeks of preparation. The speed here indicates the defense had anticipated this move and prepared accordingly well in advance. By Wednesday morning, the Supreme Court had accepted the petition, assigned it a docket number, and placed it on their calendar for consideration. Crucially, however, the justices issued no temporary halt. A stay would have frozen the entire process pending their full review. Without one, proceedings advanced uninterrupted while the court weighed the matter. That lack of immediate intervention carries real weight. When the Supreme Court grants a stay right away, it often signals that at least some justices view the position as plausible. Allowing the case to move forward without interruption generally suggests skepticism toward the claim. Then, this morning, Thursday, at precisely 10:30 a.m., the court delivered its response in a single line. Application denied. No justice recorded a dissent. Justice Thomas raised no objection. Justice Alito stayed silent on disagreement. Justices Gorsuch, Kavanaugh, and Barrett, each appointed during the prior administration, joined the consensus as well. The denial was complete and unified. When the court produces even a concise written explanation, it usually means the issue warranted some clarification. A bare denial with complete agreement among the justices signals that the claim lacked sufficient substance to merit extended discussion. In more than 3 decades of tracking major cases, I've seen this level of outright dismissal only a few times. And each instance involved arguments so fundamentally flawed that the court saw no need to spell out the reasons for rejection. So that's the complete timeline across those 72 hours. The proffer arrived Monday, the emergency filing came Tuesday, the court took it up but declined to pause anything on Wednesday, and the denial landed Thursday. Now let's examine the actual contents of that proffer agreement, because the evidence outlined there carries far greater implications than many reports have captured. The document organizes the offered material into 3 distinct groups. The first concerns financial paperwork indicating awareness of misleading valuations of assets. She co-signed federal tax returns covering 2014 through 2020. 6 consecutive years of joint filings, each signed under oath declaring the reported figures accurate. Those returns hinge on asset valuations, property worth, generated income, allowable deductions, inflating values for lenders to secure financing while deflating them for tax purposes to reduce liability, constitutes fraud against both banks and the government. Joint signatures place shared responsibility on both signers. The proffer further notes her attendance at sessions with accountants during which valuation methods were reviewed. She posed specific questions about reporting practices. Emails already in prosecutors' possession corroborate these points. The second group covers exchanges of information. This includes messages exchanged with the accused concerning asset figures ahead of lender discussions. It also involves correspondence with accountants probing discrepancies between lender presentations and tax submissions. Additionally, there are audio recordings of telephone discussions tied to loan requests where precise valuations came up. In federal matters, recordings made in compliance with consent requirements serve as admissible evidence. Since these appear in the proffer, authorities have already vetted their legitimacy. The third group centers on supporting testimony. She stands prepared to affirm details accountants presented to the grand jury. She can confirm banker statements given under oath. She can validate claims from appraisers about requests to overstate property worth. In federal prosecutions, multiple confirming sources create formidable strength. One person's account of a meeting carries weight. A second person's matching recollection strengthens it considerably. Documentary proof from the same event establishes an irrefutable pattern that defenses struggle to dismantle. The most striking element within this proffer is her explicit waiver of spousal privilege. Ordinarily, the law shields spouses from compulsory testimony against one another to preserve marital confidence. Yet that shield exists for the witness to invoke or relinquish at will. Her agreement clearly states that she waives the privilege entirely with respect to the subjects addressed. Prosecutors applied no compulsion here. The initiative came from her side. Voluntary spousal cooperation has appeared in past high-stakes matters, wives of organized crime leaders testifying to secure their own position, or executive spouses in major fraud inquiries stepping forward upon recognizing mutual risk. Still, never before has this occurred involving the spouse of a former president, bringing forward records, messages, and first-hand accounts that bear directly on alleged federal offenses. The emergency Supreme Court petition raised 3 central contentions, each of which collapsed. I'm really struck by how this matter continues to develop. What's your view at this moment? Leave a comment, whether you agree, disagree, feel surprised, or anything else. Your input always adds depth. Just hit the comment section. The lead argument asserted that spousal evidence would breach marital privacy rights protected by the Fifth Amendment. Yet more than a century and a half of Supreme Court decisions affirm that the privilege belongs to the testifying spouse and can be surrendered voluntarily. The controlling precedent, Trammell v. United States from 1980, holds that the witness, not the accused, decides whether to invoke or waive it. Once waived, the accused holds no veto. That principle remains intact and binds every federal appeals circuit. Thus, this position lacked any grounding in current law. The next claim suggested the proffer resulted from coercion, intimidation, or undue influence by prosecutors, rendering cooperation involuntary. However, the submission includes an affidavit from her own counsel affirming that she initiated contact with the special counsel's office. Her attorney originated the proposal, outlined the terms of cooperation, and handled negotiations. No subpoena compelled her, no threats surfaced. The entire step was voluntary on her part. Federal courts apply a straightforward test for voluntariness. Were charges threatened absent cooperation? Was personal liability leveraged as leverage? When neither applies and the witness approaches authorities independently, courts deem the action voluntary. Her lawyer's sworn declaration dismantled any allegation of pressure. The final contention warned that permitting such testimony would erode marital privacy across future matters. But that concern ignores settled law. Spouses frequently testify when they elect to do so, as Trammell confirmed in 1980. The defense essentially sought a unique carve-out based on the accused's identity. The Supreme Court declines to tailor rules to individuals. Equal application stands as a core principle. When the justices issued their terse, unanimous denial, the message rang clear. The positions advanced were not merely unpersuasive, they bordered on meritless. Emergency Supreme Court relief demands demonstration of imminent, irreparable injury, plus strong likelihood of prevailing on substance. This petition met neither threshold. Allowing testimony to proceed aligns with ordinary judicial process. Prevailing would have necessitated reversing Trammell, a step no justice entertained. With the Supreme Court avenue closed, the grand jury can proceed to hear from her shortly. That body convenes Tuesdays and Thursdays in the Southern District of New York, standard for this venue. Assuming prosecutors stand prepared, and the proffer implies readiness, she may testify as soon as the coming Tuesday, or within the next week at latest. Following her appearance, prosecutors will weigh two paths. One involves bolstering the present 34-count indictment for falsifying records and related bank offenses. Her details on joint returns, accountant meetings, and corroboration would fortify existing allegations. The alternative entails pursuing a superseding indictment incorporating fresh counts drawn from her contributions. A particular March 2020 call highlighted in the proffer merits attention. Her presence during a discussion between the accused and a banker regarding valuations prior to a financing request. Should that exchange involve coordinated misrepresentations, both knowingly endorsing falsehoods, it fits conspiracy to defraud a financial institution. Conspiracy requires mutual understanding to pursue unlawful conduct plus an overt act. The conversation supplies the agreement. Advancing the application fulfills the act. If provable via her account, additional charges become likely, expanding exposure considerably. The trial remains set for September 16th, about 28 weeks out. Absent further blocks, privilege assertions, or procedural holds, that date will stand firm. This matter establishes several lasting benchmarks for federal enforcement. First, it demonstrates spousal cooperation, even in cases touching the pinnacle of national authority. Past examples exist in racketeering prosecutions, wives aiding cases against mob leaders in the 1980s, or corporate spouses during Enron-era inquiries. Yet none matches this scale. The spouse of a former chief executive supplying documents, exchanges, and direct evidence implicating federal violations. Prosecutors now possess clear Supreme Court backing that voluntary waiver overrides privilege when shared exposure exists. Second, the court's prompt, unanimous action underscores that marital privilege claims cannot serve as tools for stalling legitimate proceedings. A one-line denial without dissent sets a firm marker. When waiver occurs freely, privacy-based emergency petitions will fail. Future white-collar defenses can no longer rely on such tactics to gain time. Third, it reaffirms equal accountability regardless of status or resources. Affluent parties have long employed layered motions, appeals, and claims to prolong matters, banking on fatigue or shifts in climate. Here, judicial firmness prevailed. The trial court enforced its calendar, the Supreme Court swiftly dismissed obstruction, the grand jury advanced unhindered. Institutions upheld the rule of law through decisive, even-handed application. Looking ahead over the coming month, three developments will illuminate the prosecution's direction. 1. Grand jury patterns. Fresh subpoenas within the next couple of weeks would signal pursuit of expanded charges. The volume of new appearances correlates directly with potential count increases. 2. Defense filings. Expect a routine motion challenging her participation. The precise grounds chosen will reveal vulnerabilities. Attacking recordings points to their potency. Questioning reliability suggests documents pose the greater threat. Such responses expose the prosecution's most formidable pieces. 3. Finalization of any immunity deal. The proffer represents an initial outline only. Complete protection demands a binding cooperation contract detailing obligations and safeguards. Full transactional immunity. Limited use immunity, or otherwise. Filing that agreement will disclose the precise scope. Ultimately, the Supreme Court declined to elaborate because precedent already governed clearly. Privilege yields to voluntary waiver. Testimony proceeds. No individual stands exempt, neither through affluence, connections, nor protracted litigation. The process functioned precisely because established rules guided every step. This is Jeff Desk. Stay awake, America. We'll see you in the next one.